Hey guys, this is John Watts. I'm a consumer protection lawyer. I appreciate you watching this video. We're going to look at an IRS tax court decision. And the lesson of this is when the IRS says, when you're trying to work out a settlement, hey, we need these documents, you have to provide those documents. When they say, hey, here are the rules you have to follow, you must follow those rules. It's kind of like in court. Sometimes we'll see people maybe that are representing themselves and they'll face a summary judgment motion and they'll say, well, I don't like that. I just want to argue a case to a jury. Well, if you don't follow the rules, you never get to the jury. Same thing with the IRS. The IRS is very much rules driven. And so if you want, for example, an offer in compromise to be considered or an installment agreement to be considered, then depending on exactly what we're talking about, you may have to submit this form or do this or do that. Well, it literally is like just a checklist. If you haven't done it, you don't get even a consideration on the merits of whether you're entitled to an offer in compromise or an installment agreement or penalty abatement or whatever it might be. Have to submit the required documents and follow the rules. So this is a tax court decision back in May of 2020. And so let's look and see what happened here. So it's collection due process case. The taxpayers seek review because the IRS said we're going to uphold a notice of intent to levy, which means they're going to seize wages or seize property. And so the IRS moved for summary judgment, and they said, look, there's no issues of material fact that are in dispute, and what the IRS person did was proper. And the tax court says, we agree. So here's the background. Have a delinquent federal income tax return for 2014, taxes due of $14,000. Here's some credits. They failed to pay the balance due, and so there's penalties for failure to timely file, failure to timely pay, failure to make estimated tax payments. And so here's the total liability. It's almost $10,000. So the IRS sends out a notice of intent to levy and notice of your right to a hearing. And so the taxpayers, and I point this out in all these videos, I always want to compliment taxpayers when they do this because so few people will do this. They timely requested a CDP hearing, which is a collection due process hearing. And they said, hey, look, we want installment agreement. We cannot pay the balance. We have other expenses and we would request halting IRS action until we're in a better financial position to pay. And so they request an alternative method to collect taxes. And they did not say they were challenging the liability. So in almost all of these tax resolution cases, we are not challenging the actual liability. I mean, we owe the money. Okay? It's really just about collectability. And so in this situation, they did not challenge the liability. So we get the settlement officer. And one reason I want you to see this is because they're dealing with a government shutdown. And those of us that have just experienced the last 4 or 5 bizarre months here with COVID-19, there may be something similar here. And so I want you to see kind of how the court and the IRS handle this. So we get the settlement officer, and this is pretty typical, sends a letter scheduling a telephone collection due process hearing for this date. And in that letter, it says, look, we'll go over collection alternatives, but in order to be considered for a collection alternative, you need a completed Form 433A. It's basically a financial disclosure type form. And you need to send me copies of your signed income tax returns for 2015 and 16 because my records don't show those being filed. Okay? So whenever you're asking for any collection alternative, you must be in compliance. You must have filed your tax returns. And you may not be able to pay everything, but you've got to at least make an effort, okay? And what so many people do is they just don't file the tax returns. So we have a lapse in government funding, and so this is the government shutdown. So they couldn't conduct that hearing as scheduled. Remember, it was scheduled for, the 15th? Yeah, January 15th. And so on January 30, The settlement officer tried to call them to reschedule. She left a message and she didn't hear back from them. So she sent a letter and said, hey, I've rescheduled it for March 5th. And by the way, I don't have any of those documents that I requested. And if you tried to fax them during the shutdown, our fax machines were disabled during the shutdown. Isn't that a nice touch? They just say, well, government shut down, we just turn the fax machines off. But now our fax machines are working. So in February, remember the hearing is set for March 5th. So toward the end of February, she got a 433F. Now, if we back up, she wants the 433A, okay? And the F is similar, but you can't do an offer and compromise with that. And the court points out the form was incomplete because it omitted the husband's income and it omitted the supporting documentation. So March 5th, she called them for the rescheduled hearing, but she couldn't reach them, so she left a message. And then the next day, she sends what's typically called a last chance letter and said, hey, you missed the conference. Why don't you send me within 14 days any information you wish for me to consider? And she said, I did get that 433F, but I need that supporting financial information, proof of income, bank statements. So the taxpayers did not respond to that last chance letter. They did not communicate with the settlement officer. So she closes the case. And she notes they had not yet filed tax return for 2015 or 16. So the settlement officer says, hey, your liability for 2014 has been properly assessed. The requirements have been met. So April of the same year, 2019, they issue a notice of determination sustaining the proposed levy. Now the taxpayers get moving. So they file a timely petition. They said, hey, we gave all the necessary documents. We want another opportunity. They said we had a telephone problem. We didn't receive all the messages. I don't know if that means they received some, but not all. And they did get that last chance letter, but stated their belief that their only recourse at that juncture was to petition this court. So it was just a misunderstanding by the taxpayers. They did not understand how to properly go about their rights, to preserve their rights. And so then we're dealing with summary judgment, which we won't get into that very much. Just point out where the underlying tax liability is not at issue, the court reviews the IRS decision for abuse of discretion. So it's not just, well, I would have made a different decision than that settlement officer. It's got to be arbitrary, capricious, without sound base. I mean, it's got to be pretty bad, okay? So how do they figure out if an abuse of discretion occurred? Well, they look at three things. Number one, requirements of any law or procedure. Have those been met? Number two, look at the relevant issues that have been raised. Were those dealt with? And then number three, any proposed collection action balances the need for efficient collection of taxes with legitimate concern of the taxpayers that the collection action not be more intrusive than necessary. And they say, hey, we think she did everything she's supposed to do. So she verified the liability had been properly assessed, everything had been satisfied. Petitioners were entitled to request a collection alternative. So it could be offer and compromise. We have a video on the three types of offer and compromise. Or it could be an installment agreement. But here's a mistake that was made. And I'm not saying the IRS makes it real clear, okay? But here's the mistake. But petitioners made no concrete proposal for a collection alternative, and the settlement officer was not required to make one for them. It's kind of like when we appeal in a normal court case. And the appellate court says, well, you didn't point out the errors that the trial judge made. Or you pointed them out, but you didn't show us where they happened. And we're not going to go digging through, a 2-week-long trial transcript to find this. Or you made certain legal arguments, but you didn't give us the case law that supports that. We are not doing your research for you. Same thing here. The settlement officer is not required to offer you something like, hey guys, you probably could qualify for an installment agreement or a penalty abatement or an offer and compromise or whatever it might be. That's not the requirement of the settlement officer. And so the court points out, well, the taxpayers submitted a partially completed 433F. They failed to supply the supporting financial information. So look, this is nothing new. The court says we've consistently held it's not an abuse of discretion to reject collection alternatives, sustain the collection where you don't supply the necessary documents, as long as you were given sufficient opportunities. And then the court says, in any event, you failed to establish compliance with your ongoing tax obligations because you didn't file 2015-16. That by itself is enough to reject any collection alternative. So again, so many people make this mistake, even people that operate kind of in my world doing tax resolution. They will submit an offer in compromise and the taxpayer hasn't filed their taxes for the current year, even though they're due. Well, you're automatically rejected. So all you've done, there's no way that offer gets accepted. And all you've done, and we'll point this out, it may have already been released or will be shortly, about statute of limitations. There are certain things that sort of freeze or pause the statute of limitation for the IRS. One of those is making an offer in compromise. Until it's rejected, it freezes statute of limitations. So when we make a bad offer in compromise, all we're doing is giving the IRS more time to come after us. And if we paid a tax resolution person, whether a lawyer, a CPA, or an enrolled agent, money for a bad offer in compromise that's not going to be successful, we're just wasting our money and giving the IRS more time. So anyway, let me go back to this. So, there's this issue about the voicemail, and they say the petitioners acknowledge that last chance letter, and the settlement officer even waited a month after that deadline, which was 14 days, to then sort of close everything out, okay? And the point here is, if you're dealing with the IRS, even if you're late, it's better to go ahead and send it, okay? Now, there's some things in the law where we just miss it, we miss it. If we miss the deadline to appeal, there's nothing we can do in a normal legal case, okay? But with the IRS, even if you're late, even if something bad has happened, it's better to take some action and try and salvage it than to just do nothing. And the court says, we don't find any abuse of discretion, so we grant summary judgment. And this is an important part here that they note. They say, we note the taxpayers are free to submit to the IRS at any time a collection alternative, whether that's offer in compromise, installment agreement, but it's got to be supported by the necessary financial information. So they're kind of telling the taxpayers, look, you lose, but if you can properly submit a collection alternative, it'll be looked at. And so that's kind of the bad news for the taxpayer is you lost and the IRS is going to go get their money. But the sort of one positive from this is you can still try and make an attempt. Maybe it works, maybe it doesn't work, but you've got to supply everything. Okay. Let me show you a couple footnotes here. Yeah, this form 433F is similar to the 433A, but it cannot be used to support an offer in compromise. So their point in saying that, I believe, is that because you submitted the wrong form. And look, it's 433F instead of A. They're very similar. There's so many numbers with the IRS. It's easy to get confused. But you've got to submit the right forms and the supporting documentation. And then they also point out that the underlying tax liability was not disputed in the petition or during that CDP, the collection due process hearing. And you must present an underlying liability challenge. In other words, where you say, I don't owe you any money or I don't owe you this much money. You've got to do that in the collection due process hearing to preserve the challenge for judicial review. Now, if you admit that you owe the money, you can still try and do an offer in compromise or an installment agreement. You just can't go back later and say, well, actually, I don't owe any money, okay? You owe the money, but you may be able to get some help on exactly what you will end up having to pay. And again, I'll put this link in the description. So the lesson from this is submit all required documents, and you've got to follow the rules. And it's a challenging situation for these folks. And I feel bad for them because they were operating without a lawyer. And, you have this government shutdown when you're supposed to have your collection due process hearing, and then apparently they were having an issue with their phone. And so it's just kind of a whole bunch of factors have come together that really made it difficult for them. But if we're going to do this on our own, we've got to stay on top of it and be very aggressive about making sure every single thing that we're supposed to give the IRS, we've done it. And, the best thing is to do it on time, but it's better to do it even if you're late than to not do it at all. Okay, guys, thanks for watching this video, and I'll catch you in the next one. Bye-bye.